No matter your age or wealth, estate planning is imperative for the financial security of your loved ones and your own peace of mind. Attorney Sean Hagan is a Kingston resident and partner at the law firm Hagan Huff-Harris and specializes in trust and estate planning. I spoke to Sean about the importance of estate planning for everyone. Let's jump right in. So there is a misconception that only people who have high net worth need estate planning. Can you tell me why that's wrong?
Well, I think that it's the phrase. So estate planning, when we think of the word estate, we think large estate, country estate, multiple properties, that sort of thing.
Yeah.
But estate planning is really just putting proactively documents together that will address both incapacity and death when you pass away, right? So that's, a lot of people know of a will, right?
Yeah.
Wills, trust, power of attorney, these are the documents that we're talking about with estate planning. And I'm very fond of saying, if you have a smaller estate, each dollar matters that much more. So it's actually very critical that you have a plan in place, as opposed to a very large estate that would have a lot of money to spend on sort of fixing things later, right? So like many things in life, if you do a little planning in advance, you tend to save money, and that's what I primarily do for clients, proactive planning.
Excellent, excellent. So what is the process like? Somebody comes to you and they are a middle-class family, somebody from one of our 4 towns.
Sure.
What does that look like?
So a family comes in. It's not always a family. It's really important for individuals to get plans as well. But let's take like your average viewer, married, maybe 1 or 2 kids, own a home, like they have a mortgage on the property, like most of us do, maybe 1 or 2 people are working in that family, that's a sort of a setup there. It usually begins with a complimentary consultation.
Huh.
So my offers that. Not all lawyers do. So if you hear that the local lawyer you're looking at has a consultation fee, that's not a reason to say, oh man, let's move on. It's just that we have this commitment to not having a consultation fee for estate planning. And so that is the first step. And then it's a matter of scheduling that consultation. And it can happen on Zoom. A lot of lawyers are just doing Zoom exclusively. We offer both Zoom and in person at the offices, either Boston or Duxbury, our 2 offices. And it's a conversation. So I'd say no matter who you're working with, you'd usually expect to sit down with that lawyer. A lot of times it's 30 minutes. We do an hour because we feel like it's too short, but 30 minutes to an hour, it's probably not going to be a 4-hour thing, where you sit down with a lawyer and you're trying to evaluate whether or not you want to hire that attorney, and they're trying to give you information about what you actually need. So our consultations tend to focus on the types of assets people have rather than the full value, because most clients, if they own a home, are going to have a tax issue, which I can talk about later. So that's sort of out of the way. So it's more about the types of things you have. Do you have a small business? Do you have an additional property on the Cape or New Hampshire? Do you have a child with special needs? Do you have pets that you want to plan for? And we actually do quite a bit of that.
Wow.
So it all matters, your actual, situation with the types of things you have and your family situation, in determining what you need as far as a basic plan or something more advanced. And so that's that exploration in that first meeting. And then once we determine that, we provide upfront what the cost will be at the end of that meeting and what the process is going to be like. So you have a clear indication. The next step, once you sign up, would be to do a design meeting where you sit down with usually 1 lawyer. We tend to do it with 2. Usually have myself and an associate join. I think that, 2 eyes and ears are better than 1. And we sit down and we go through a worksheet that they've already filled out. And that worksheet really gives a lot of detail, more than just the conversation did initially during the consultation, about the types of assets they have, their information about their family, all of those things, what they're thinking. But we often use that as a way to reframe things, because the clients that we have never done this before, most of them.
Yeah.
And so they really don't know what they're getting into, right? So they need to rely on us to guide them through what their preliminary selections were, and maybe make some alterations and explain why we're choosing different people for different jobs. And then once we finalize everything and they're comfortable, that's when we would set the date for signing the documents. And estate planning documents do need to be signed in person, unless we're doing it under the remote law, which is an emergency law during COVID. But most lawyers reserve that only for I'd say most sick patients that really can't be accessed. Clients that are patients in a medical setting. So you're going to sign in person with your lawyer. So even if you do Zoom initially, there will be that physical in-person signing, because it has to be in front of 2 witnesses and a notary public. And then once that's done, the lawyer will provide you your documents and you'll be on your way. So that's the full process, some variation depending on how you do it. But there's that initial meeting, the actual planning part based on the information you provided, and then the actual signing of the documents. And then the funding starts, which is something you have to go to different banks and different financial institutions and get that all worked out. So that's the whole process. That's usually spread out over a month or two.
Oh.
Some lawyers take longer. It just depends on how busy they are, and especially whether or not it's a primary focus of that law office or something that someone's doing on the side. If they're also a litigator, that might take, like a lawsuit, issue going to court, that might take precedence. So some people do this sort of on the side, and I usually don't suggest that people, go to a lawyer that it's not their primary focus, but sometimes they prefer to do that because they really know or trust that lawyer.
And that's an important relationship, right?
Totally, because it can be, well, you have to trust them completely, right? It's your family and your money.
Yeah.
And there's few things more important than those two things. So you want to make sure it's done right. You want to make sure it's done by someone that has a, focus in this area. It's not a side practice, and that you feel comfortable with. Because at the end of the day, you're giving a lot of information that's sensitive, and you're asking for help, guidance on how this can be crafted for your family so that you're minimizing conflict, minimizing fees. Mm-hmm. I think that a lot of people view this as something they just need to check off their list, their to-do list.
Yes.
We get a lot of New Year's resolutions, getting in here, getting their estate plan done.
Yeah.
And then when they get into it, the usual response is, well, I didn't know there was this much to think about. I'm so glad that we are, and I feel so comfortable now. And there's a sense of relief. But many people start this process not realizing the impact it can have, either positive or negative, done the right way.
As part of estate planning, do healthcare proxies and durable powers of attorney also play into estate planning, as you described?
Yes, they do. That's all part of an estate plan. I would say the average basic estate plan includes a last will and testament, a revocable trust, and there are many other types of trusts, but as a core planning document, the revocable trust, a power of attorney, and the healthcare documents, which is the healthcare proxy, a HIPAA authorization, so a list of people authorized to receive medical information only, usually a bigger list than the healthcare proxy itself, and a document called a living will. And that's also called an advanced care directive in other jurisdictions. And we find that those healthcare documents are actually equally important to the financial documents and the other documents, because the healthcare clarity that comes from putting it down the page really prevents a lot of fighting. And I like to think we're in the fight prevention business as estate planners among heirs, as well as saving people money.
When you mention power of attorney, as people mature, people want control, right? But a power of attorney protects them for the future. Is there a kind of device like if this, then that in a power of attorney?
Yeah, most of our documents, so all the documents I just mentioned are all able to be changed by the client going forward. And none of them are relinquishing control, okay? It's an if situation. So if you can't act, then I've got this person stepping in. If you need someone to manage your legal affairs and financial affairs, then they can actually step in and do that. The exception to that would be a common type of trust not mentioned previously in this interview, which would be the a situation where you have long-term care concerns, right? So Medicaid Asset Protection Trust is different in that you're putting all your assets aside into this trust, or maybe just the house or whatever, and you are giving up control. And the reason why you're giving up control is you're hoping to qualify for mass health Medicaid benefits later. And this is the whole thing about, the nursing home. And it's really the state, not the nursing home, but the nursing home taking your house or whatever. Which is not exactly how it works. But for clients that it's a good fit for, they'll actually be taking the assets, moving it in. They do lose control, which we always highlight, but then they're waiting 5 years. And it can work out very well in certain cases. But I don't want to confuse the viewers with this idea that if they do a basic plan, they're giving up control. It's quite the opposite. You're taking control of the current situation. Nothing's changing for you. And then if something happens to you, then you've got clarity around who's making healthcare decisions, who's making financial decisions. It's not giving up of those things yet.
So it's peace of mind, right?
100%.
100%.
And that's honestly what drives me, right? When people are like, we feel so relieved that we got this done and that everything's all set. And that's really why I really enjoy the practice.
You mentioned revocable trust as a imperative for a basic estate plan. Why
That's right.
Revocable?
the reason why, and this is something you might see if you Google online, like, do I need a trust? And I think it's one of those clickbait sort of things. No offense to media, okay?
No.
But you guys are great.
Thank you.
It really is something, most people are going to need it because most people that we would see, they do have a home, they do have a bank account, they do have assets, right? And if you do, the trust provides excellent incapacity planning. So if you're in a coma or in the hospital for a time and you need someone to step in just to pay the bills, make sure things get done, that's where the trust really shines, even more so than a power of attorney, which is the traditional document used for that. We're seeing that if those are done a number of years ago, a lot of banks are wanting you to either redo them or they're not accepting them if they can't be redone, like if you're in a coma. But the trust is above suspicion in many ways. So the trust becomes the primary incapacity planning tool, okay? And the other reason why everyone needs this is ease of estate administration. Going through the probate process in Massachusetts has not improved, unfortunately. There was a big change in 2012 to try and have the probate process be improved. And it kind of convoluted things a little bit. So it actually takes quite a long time. COVID has not helped. And there's really a block on access to assets. So for anyone that has just a will alone or no will at all, they're going to have to go through the probate process for the majority of their assets. And that's a year-long process with court, the appointment of a personal representative of your estate, and there's delay in access to funds. So just for that reason, especially smaller states, there's not just a boatload of cash to address issues. Each dollar matters. We need to be able to access that quickly, even to pay for funeral expenses, right? The other thing is the cost savings. When you do a revocable trust, you hopefully avoid those probate fees. And the fees between the filing fee, publication fee, initial legal fees, it's often around $2,000, just to get started with it. And then you have that, less access, right? Until you actually get appointed. So it's really one of those things where the cost is a factor as well. That's why everyone needs it. And the third thing is the vast majority of people that own a home in Massachusetts are going to have a state estate tax issue. We currently have $1 million threshold, which is one of the lowest in the country. And we have some of the highest home prices in the country, right? Massachusetts, sure, right? It's not probably a surprise, but most people are going to owe state estate tax unless they do one of these revocable trusts, either lower or in some cases actually eliminate the taxes that are owed. And the important thing to keep in mind, if you have a home and it's worth $500,000, but you've got a mortgage on it, for purpose of calculating whether or not you're going to owe estate tax, it's actually the $500,000. It's the fair market value, not right. I mean, you end up not having to pay on that full amount, but it triggers the tax in Massachusetts. And this is very different than the federal estate tax. So the state estate tax is what's called a cliff, and it's pretty bad because you can trigger it very easily. Most clients hit it. So I'm on this mission to try and lower the amount that people pay in taxes, and we do that through the basic revocable trust. So for those reasons, your average person really needs this, even though they might be thinking, well, I just need a will, I don't need anything fancy, we're very simple. That's often the conversation I'm having. And then I just get to lay out all the reasons why they need it in an educational way, not in a scary way. And then they make the decision to sign up, and that's a very helpful thing for them and for us.
That's excellent. So as society has evolved, digital media and assets, people monetize websites and blogs, and also simply have social media accounts that have a value to them, a personal value. Is that something that should also be included in estate planning?
Absolutely. And this is an evolving area. I would say even as recently as 5 years ago, this was a particular issue with the online accounts. These softwares didn't really have a plan for what would happen. And then Facebook kind of led the way a little bit with their legacy accounts, but the rules are very strict. It's also the sort of thing that we all just sign up for whatever service, or even just having the, our photos, right? Held by some sort of a server or cloud. We all click through and just say, all right, I'll sign up for the service. And each one of them has a different way of dealing with this. A few years ago, there was this movement to try and create a digital executor. This is getting far more academic than probably for general viewership, but there's a movement towards clarifying this. But in the current state of things, it's mostly been focusing on the actual services themselves having a mechanism by which they can release that information. There's also debate about whether or not the decedent wants this information released. whether or not it's, personal emails or anything like that. I mean, I would just say sometimes it might be better not to know all the details. We have this idea that our email is fairly private. And so there is a debate going about whether or not, someone should have full access to that, right? It's like someone's diary effectively, right? So there's a growing consensus that there should be just a mechanism within each software to name someone as a beneficiary of especially the things that have value, okay? And even the things that don't have intrinsic value, getting access to them. There's a lot of stories in the news about people not being able to access online, images and things, and their son died, and all of that, and it's very heart-wrenching. So the software companies have finally responded. There is a mechanism. Now, as far as other types of digital assets that have true value, such as cryptocurrency, this is an evolving area, but this is very critical. And it's one of the questions we always ask. And sometimes it feel a little funny asking it because, you might look at the couple and think they probably, they don't really say they use email that much. I doubt they have crypto, but like, let's make sure, right? Because you just don't want to have that huge loss of value. And we are seeing a lot of clients that have accounts that they call play accounts, where they might put $2,000 or $3,000 into it, but we still don't want to lose $2,000 or $3,000, right? It's not nothing.
No.
So having a specific way to plan for that, we do get into that with estate planning, and it usually incorporates finding access, separating pieces of information, almost like a treasure map situation, to be able to put the pieces together in the event that someone passes away so they can access the crypto. And also I would say that the crypto, like the companies that are doing this, are also finding mechanisms to have a named beneficiary. So we're getting there, but it's still definitely something that can, there can be major mistakes with people not being able to access the crypto and it just being gone.
Wow. So currently, if someone comes to you and with their social media accounts, also crypto accounts, the methods and devices to protect those are still evolving, but that's something you can help them put into
one of the
place.
things we often suggest is they do what's called a VAIL, or virtual asset instruction letter, where they're able to write down things like passwords and things like that, and of course they have to keep it up to date, which is the problem inherent with that. Also, there's softwares that change around the passwords, so that's kind of the best we can do for immediate access, especially among spouses. So that's what we instruct, but we also put in all of our trusts, at least, and the will, there's information about there that says these fiduciaries have access to our digital assets. So the documents themselves reflect the ability of that person to access it, but it's really going to be on a contract by contract basis with each service provider.
Excellent. How should a person choose their executor or trust administrator?
So I think that the main thing to think about is not the closeness of the relationship, but the ability of the person to do a job like that. And I usually advise that if the person has an ego, they're probably not a good fit. They have to be willing to ask for help. They have to be willing to maybe hire a lawyer to have help with that process. And they are best, I think, when they have proven they're capable when it comes to their own financial life. Doesn't mean they've just made a lot of money, but just we're looking for good decision makers, because they're really your chosen person to act on your behalf in pretty critical situations. So choosing that person, it has to be the right person. And in certain cases, it ideally is someone that's located within the United States due to some foreign trust reporting issues. But outside of that, it's part of a big part of our design meeting is to explore who they're thinking about, and is that person really the best person? Or is it just the eldest child? And maybe we should think a little bit more about that than just being like, well, they're the oldest one. We'll make them
the default.
The trusted.
Should the executor be the same person who's a trust administrator, or if you have young children or even adult children who are disabled, guardians, should that be the same person, or is there a benefit to having those people be different people?
That's a great question, and it's another one that happens at the design stage. We dig into that. And what I would say is if you have a deep enough bench of people, sometimes families only have one person they trust for both of these sort of areas, we do like to have a divide between the guardian of any minor children and any of the other financial jobs. And the other financial jobs really are the trustee, the successor trustee, after the couple or after the client, the power of attorney, the agent of that, the attorney in fact under that, and also the executor of the estate, known as the personal representative in Massachusetts. So those three financial roles, we're actually often suggesting it might be good to have that be the same person, because they're all financial and it makes it very simple. Some people do like to separate it, but I think the one that we're often advising on a divide is guardian versus the other financial roles. On the theory that the guardian has quite a lot to do being the de facto parent, but also when the money is separate, it gets preserved a bit better, because when it's all mixed together, that guardian might start to feel like it's for maybe all the kids, like their own kids and the ones they're guardians of. Or not direct stealing, okay, but there's just this convenience to it. I often use the example if the family needs a new car, really the family's benefiting from that new car as well, right? But if they just have access to everything, you could see them using the newly acquired funds for this new car they wouldn't have had to buy otherwise, right? So it gets a little bit mushy when you have one person doing everything, right? And so it really depends on the people, and I'm a big fan of spending time during the design meeting to evaluate that, because it has such a big impact.
So a family or an individual can expect to traditionally seek estate attorneys to have an intake, right, to have a design meeting. Now you have your will, you have your irrevocable trust, or whatever is appropriate for you. How often should you revisit that?
This is a great question. Marketing professionals would encourage me to say every 2 to 5 years or something like that. But the truth is, it really depends on whether or not there's been a change in circumstance in your life, or a change in the law. And I would say any, good estate plan attorney is going to try and really reach clients on major changes in the law, to update them on that. And you might hear about it too, or you might call your attorney with questions. Like, you want to be able to have a relationship with someone where you remember who they are, going forward, because you spent the time with them and you've gotten good service, and you can call them. You feel like it's not a bother to call them, to ask these questions, right? But definitely some major life changes would prompt a response when it comes to changing estate plan documents. Going through divorce is a major one, obviously, because a lot of the married couple plans are focused on benefiting the other spouse. So the moment that you are considering filing, you should really update that, so that if something happens during the course of divorce, and it's updated, it can go to the kids if there's kids, instead of your soon-to-be ex-spouse, for example. And I would say if there's a major change in circumstances related to the health of a beneficiary, let's say that all of a sudden there's an issue and there's a special needs beneficiary all of a sudden, a good estate plan will have planned for that, but candidly, a lot of them don't. And so if it doesn't have what we do as a springing special needs trust, you're going to have an issue with the beneficiary maybe getting knocked out of benefits and things like that. So I would say if there's something that causes a major change, you should reach out. The other one that we actually have a lot of people reach out to us about is, when someone's going to get married, when they've got an adult child that's going to get married, and the child's not signed a prenuptial agreement, and there's some concern over, hey, is there anything we can do? We don't exactly want everything we've built, going to their ex if they end up, divorcing later. And most of the people that bring this to us really like their future, new family member effectively, right? But they just, they're just a little nervous about it, right? The divorce can happen very easily. So that's another touch point where if there's a change in your life, we can actually do a lot to effectively divorce-proof the inheritance, even without the beneficiary knowing. It has to be structured a certain way, but we can do it. So those are some things to look for.
Again, peace of mind, right?
Totally about peace of mind.
So
and control, having things go the way you want.
Excellent. So the takeaways: do you need estate planning? Yes. If you are alive, you need estate planning. So to wrap it up, when should people start thinking about this?
We actually do quite a bit of, I'd say, very minimal estate planning, not including trusts, for college-age kids. Because I think one thing that parents don't realize, or maybe they do but don't want to think about, is the second that they're 18, they're legal adults. So the earliest we would do it is sort of college age, power of attorney, basic healthcare documents, that sort of thing. But I think the majority of people start doing this in their 30s. Oftentimes the birth of the first child, if they're having kids, that's a prompt. And then also people that are in their maybe 50s and 60s, close to or entering retirement, and they either haven't done it ever, and they're embarrassed about it, and we don't judge them. No harm, no foul. You're still here, you're still alive, right? Or they haven't touched it since the 80s or something. So those are really points in which we can do this. But the earlier side is probably I'd say 25 or 30. It just depends on if you have any assets, because you need to make choices about who's going to have those assets.
Yeah.
And especially people that are single, they often don't like the default laws, which we probably don't have time to go into, but you want to have choice about who's going to help you if you need help, both health and with wealth too.
Excellent. Attorney Sean Hagan, this has been very, very helpful. Thank you so much.
Thank you. Really appreciate the opportunity to talk. Thank you.
This is a complex topic, and there is a lot more to know and learn. We will be inviting Sean back for a part 2 in the near future. Thank you for watching. We are grateful for your attention. If you like what you saw, please like and subscribe to The Local Scene here and share everywhere. Thank you, friends.